Welcome to Trial Think, the podcast of Kenney and Sams. In each episode, our team of nationally recognized litigators and industry experts discuss how the lessons they learned before, during, and after trial can be used to reverse engineer best practices for attorneys, clients, and risk managers.
Welcome back to the most recent episode of Trial Think, the podcast for Kenney and Sams. As you know, Trial Think is an opportunity for experienced litigators and practitioners of the law to try and reverse engineer using their experiences of taking cases all the way through trial to learn from those experiences, figure out the pressure points along the way, and be able to take that knowledge and experience and advise our clients about how to evaluate potential contractual provisions or other risk management issues that may arise before litigation so that they can either avoid litigation altogether or, if in litigation, we've prepared you to have some real advantages in the slog of that battle of going toward trial. With me today are two partners of the firm, our founding partner, Mike Sams, and also one of senior counsel, our senior lawyers at Kenney and Sams, Drew Colby. Mike and Drew, thanks for joining us today.
Thanks for having us, Nate.
Thanks, Nate.
Drew, you and I met years ago. We had a case against one another before you joined Kenney and Sams when I was with the firm. But that's how I got to know you. Can you explain to our listeners how you came to be such an experienced construction practitioner? What was your path like?
Well, I've always wanted to be involved in construction, and I was a laborer in high school and college, and I looked around and saw some of the laborers and saw how beat up they were, quite frankly, and said, although I love construction, I really don't want to do that to my body when I'm 60 years old. So what I did instead is I jumped into the construction field as a lawyer, and ever since 1986, I've been handling construction cases. So that's my background.
Great. Well, we appreciate hearing.
People have been commenting on your good figure, uninjured from the year.
Thank you. I wish it was true.
You're a healthy guy, and we know, Mike and I, that you regularly participate in ice skating with guys half your age. So we appreciate that part of your life story as well. Mike, you talked earlier on the opening podcast of Trial Think about your experience, but how did you become focused in the area of construction law? I know you do a lot of other things, but construction law is a big part of your practice. How did you end up there?
Yeah, so when I was a young trial lawyer, I'd probably been practicing about 4.5 years, and I've had the good fortune even then to have had a good number of trials under my belt. I probably felt that I was more experienced than I actually was, but I remember managing partner at a law firm that I was with coming in, and he was sort of a titan in the bar, and he knocked on my door and he said, "Hey, I know you do construction law work." And I said to him, "Well, I've handled some property damage, construction related cases, and I've defended against some personal injury construction related cases, but I don't know as though I'm a construction lawyer." And he said, "Well, you understand contracts, right? And you understand the rules of civil procedure and the rules of evidence. And you think you can get up and talk in front of a jury?" And of course I said, he was my boss, I said, yes, 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 and yes. And he said, I deem you a construction lawyer. Now, the truth is...
If only it were that simple. If only it were that simple, Mike, right? I mean, there's so much more to it than just that.
Exactly. Now, he was a titan of a trial lawyer. He could try just about anything, and that's why he was confident, so confident that anybody else could and should be able to. And frankly, construction disputes they're business disputes. They're business litigation disputes with a lot of construction nuance, with different statutes that come into play, certainly very heavy contract specific. And then again, it'll also depend on whether you're operating in the federal or in the state end of things. But those were all things that I've learned since that period of time that I was knighted a construction lawyer by the managing partner, probably 25 years ago.
Well, we're happy to have Drew and Sir Mike Sams with us today, Knight of the Construction Bar, but both two of the more experienced construction practitioners, certainly in the Commonwealth of Massachusetts, if not nationally. So, Mike, we talked a little bit about the similarities of construction litigation and construction generally to other areas of law, but there really are so many niche parts of it that require you to have a real familiarity with developments in the case law. There's a lot of those that are happening, and especially over the last few years, we've seen some real developments in case law in Massachusetts with regards to construction. It's also very heavily driven by statutes, both in Massachusetts and nationally. And I wanted to take this opportunity for the episode today to talk about one of the things that I think is really helpful for clients of ours and for other practitioners to understand, which is how do you use the knowledge of statutes and of case law and of contractual provisions to be able to leverage a great result for a client. That really goes hand in glove with the idea of what trial think is, of reverse engineering based on all this experience, how you're able to put pressure points on folks earlier in the process and where you're able to make decisions and advise clients on how to give in certain areas of contracts or where to really insist on provisions. And that comes from ultimately wanting to put the client in the best position possible by having leverage. Mike, can you speak to sort of some of the general principles of leverage and where you can find them? We'll talk today about things like the Prompt Pay Act, mechanics liens, contractual provisions, including provisions like having attorney's fees language in a contract, and also various types of bonds and how they can help with leverage. But when we talk about leverage, Mike, how do you mean it, and how are you trying to gain a foothold to be able to apply leverage to get a better result for a client?
So, Nate, specifically with regard to cases or disputes where our client is seeking to get paid, the traditional leverage is going to be on the side of the party holding the money. And the reason for that is they're holding the money, you need the money. To get the money, you either need to make a deal, which entails making compromise and giving up perhaps more than you should have to just to get some now, or trying a case for 3 to 5 years. And that's what the side who's holding the money knows, that they've got that built-in leverage. So what you're asking, I think, in essence is how do you flip that leverage to try to give yourself a better fighting chance to get to a faster resolution and a better return on investment for the client. One of the ways to do that is by pushing the prompt pay statute, which it has been around for a while, but more recently, and I'm now starting to become a little bit of a while too, a couple years ago, the Tachi case came out and brought the prompt payment statute to light. If I can,
Mike, let me just ask you, the Prompt Pay Act in Massachusetts, that's been around for some time. The decisions more recently in the last couple of years have put some teeth on that statute by virtue of decisions of our appellate and Supreme Judicial Court. But speak to what is prompt pay. A lot of the folks listening are familiar with construction and understand these acts nationally, but in Massachusetts it's been around a bit. Talk about the Prompt Pay Act and how the case law has evolved over the last few years and how it's changed to give leverage to maybe the Davids that are fighting the Goliaths in the construction world.
Sure. So let me tell you sort of the purpose, how it works, and the recent case. And I'll do it in a nutshell so nobody either falls asleep on the storytelling or gets lost in the nuance. The purpose of the statute is that an owner doesn't get to have the contractor and then all of the subcontractors bankroll the project, which historically was happening in Massachusetts because the owner would hold payment far too long. And so in effect, the contractor and then really through the subcontractors especially, they ended up building this project on their backs at their cost because they got to keep paying their people and they got to pay for materials and equipment and supplies. So the legislature effectuated this statute that was drafted. It came out of Associated Subcontractors in Massachusetts, but it also benefits the general contractors because it applies to owner requirements with respect to payment as well. Here's how it works. General contractor submits a payment application. Under the prompt pay statute, the owner has 15 days to approve or reject. It can do it sooner, but if it doesn't do it within 15 days, the payment application is deemed approved. The owner then has 45 days from that approval, that deemed approval, to make payment. But within that 45 days, they call it the clawback period, the owner can do what it should have done within the first 15 days and reject or partially reject if that was its intent. If it doesn't reject or partially reject in the manner that the statute requires within that 60-day period, then payment is due to the contractor as a matter of law, regardless of whether the owner has defenses. The time frame then trickles down from the general contract, or from the owner to the general contractor to the subs, in the following way. The general contractor has not 15 days, but 22 days to approve or reject subcontractors' payment applications. And in the same way, if the owner doesn't do it within 15 days, if the GC doesn't do it in 22 days, those payment applications are deemed approved. General contractor then has 45 days to make payment or to properly reject. And if it doesn't, now a total of 67 days, so it gets 7 more days than the owner.
And what's the logic, Mike, there with to tack on additional days as you go down each tier?
Yeah, it's a recognition that each tier down is looking to see what the tier above is doing with respect to payment applications so that it can make a determination and sort of process or properly reject. And then the subs have, instead of 22 days, they get 29 days plus 45. So that's how it trickles down. What the Tachi case made clear, that's the one that has sort of sparked everything, is that the statute means what it says. And what it says is to properly reject, not only do you have to do it within the right time frame, but you have to provide a factual explanation, a legal explanation, and then, just as important as explaining the factual and the legal, at the end, you have to certify that the rejection was made in good faith. And if you don't do all 3 of those things within the time frame, it is as if you didn't reject. Your time expires to properly reject, and you will have to write a check. That's what the Tachi case stands for. In that case, Tachi was looking for multiple millions of dollars plus multiple millions in interest. They were able to show the court, here's when we submitted our payment applications, here's what we received and when we received it. And they were able to show the court that the owner's rejections either weren't timely or they didn't include factual and legal. And if they included factual and legal, none of them included the certification of rejection in good faith. And so the court said, you got to write a check, owner. It went up to the appeals court. Appeals court said, we agree with the trial court. You got to write a check, owner. What is now before the trial court, and it'll go up on appeal, I'm sure as well, is whether, as a result of not timely rejecting in accordance or properly in accordance with the way the statute says, whether the owner has also waived its counterclaims. So that is a to be determined issue by the court.
Can I just add, yeah, just real quickly. First of all, the Tachi is a mass case, and the prompt pay timeframes that you're talking about are Massachusetts related. Every state is now beginning to implement these prompt pay statutes, and they might have a different time frame than Massachusetts. They might have different requirements for certification than Massachusetts, but clearly, that's the case. Yep. But the statute has incredible bite to it. I mean, this is a statute that came out of almost nowhere, and it took the construction industry in Massachusetts by storm, and it's beginning to do that across the country. Almost every state now has some form of a prompt pay, and it's really important to understand what those time frames are to pay, because at least in Massachusetts, and I suspect in other states as well, there's a very significant consequence involved for not paying in accordance with the applicable statute.
Let me ask you both that question.
Just real quick, Nate. It's just important to understand.
Go ahead, sir, Mike.
No, Drew's comments were well taken. That is, we need to understand that we're talking about Massachusetts. We also need to understand we're not talking about public projects. We're talking about private projects where the original general contract amount is for $3 million or more. The general contract, the original amount. So if it starts at 3.2, it's a prompt pay job. If the job starts at 2.9 and then goes into the threes because of change orders, it is not a prompt pay job. If it starts in the threes and goes down because of back charges or otherwise credit deducts, it is still a prompt pay job.
Got it. So it's important for folks to understand that when we're talking about, and I know we're going to get into a little bit about how you can actually use prompt pay as a sword or as a shield, and being aware that it can be both depending on where you are. That it's for private jobs. You've got a dollar amount that matters based on that original prime contract. It has to do with the size of the project. So you're not going to see prompt pay being used on public jobs. It doesn't apply in that situation.
Actually, you do on occasion. There are some states that have prop pays that relate to public jobs as well. Yep, that's why it's really
Okay.
important to keep in mind.
So, and as I understand, Tachi, Mike, it was dealing with the general submitting pay applications to the owner, but the holding and the reasoning behind Tachi applies to other tiers of subcontractors, just adjusting for, as the statute requires, the time period in which they have, whether it's the general or the owner, depending on the particular set of facts, to respond and properly reject the payment applications. Is that right?
Yes, absolutely. And the way it flips the leverage, which is the key point here, is if an owner breaches prompt pay to a general or a general does to a sub, now the party who has the prompt pay rights can move ahead if they want to. And again, recognize this is probably going to have a significant impact on your long-term relationship with the tier above. But assuming that you're at that point that you're going to be fighting about it, you can now sort of flip the script and be able to say to the tier above you, yeah, if you're forcing me into litigation, we can go that route, but I'm now going to be entitled to get summary judgment, meaning I can get judgment from the judge. I don't have to wait 3 or 5 years to get to a jury. I can bring a motion early in the case based on these payment applications and your corresponding responses or lack thereof, and show the court that as a matter of law, we are entitled to summary judgment under prompt pay. So that's the leverage flip that we were talking about, Nate. It's really the ability to hammer the other side quickly to get your result.
So can I just add one thing, Nate? So Mike, you had talked about 100% spot on the requirement that the rejection be factual, legal, and certified in good faith. At least those are requirements in Massachusetts. Just to give an example of that, so anybody listening understands what that means. Suppose a general contractor submits a payment application but doesn't submit lien waivers, and the contract requires him to submit lien waivers. The owner can write back and say, you were required to submit lien waivers, you did not. The did not is the factual part. The contract requiring the lien waivers is the contractual or legal part of it, and I'm therefore denying payment in full or in part or some other way because you didn't comply with your requirement to submit a lien waiver. And I certify that I came to this conclusion in good faith. So that's kind of the certification. That's kind of the rejection process that's at least required in Massachusetts.
Yeah, that's an important point, sort of what it means to have rejected and then certify that in good faith. It's not a rubber stamp. You have to have actually gone through the process, and I guess that's somewhat to be determined. We've talked about, Drew, the possibility that although people are going to figure out and are figuring out now how to comply with the strict requirements of prompt pay, that it's not just a matter of saying and certifying that you've rejected in good faith. But as the cases go forward, there's going to be discovery and inquiries into exactly what constituted that rejection. And so you've talked a little bit about that you have to make sure you're complying with these requirements, but also, people are going to look under the hood, and good lawyers are going to start to ask the questions about exactly what that compliance looked like. And if you didn't actually perform in good faith, but rather just rejected it and said the magic words, that could result in opening up theories of liability against people that certify that the rejection was in good faith, but the facts may suggest otherwise. Now they're looking at potential claims under the Consumer Protection Statute, which in Massachusetts is Chapter 93A. So you have to be careful is how this plays out, right? It's not just a matter of checking boxes.
It's a great point, Nate, and perhaps a good segue to talk about payment bonds, because an analogous point is under Chapter 176D when when a surety is involved in a payment claim. So by its nature, if there's a payment bond, the surety's provided the payment bond. When you go to make a claim on the payment bond, the surety is obligated under the insurance statute, Chapter 176D, to do a good faith, fair, full a reasonable investigation before it rejects a payment claim. That is, it can't just rely on its principal saying, no, we don't think the money's due, and therefore don't pay it. That's not a sufficient basis for a surety to reject. And if it relies on that, there is case law out there that would say it violates Chapter 176D, which is a violation of the Consumer Protection Statute, Chapter 93A, that triggers attorney's fees and potentially multiple damages. And so I say that because in the same way where the prompt pay statute says you have to certify your decision in good faith, to your point, if somebody doesn't really do the job of reviewing such that they can certify in good faith, there's a question, we haven't seen the case law on it, but I think it's only a matter of time where somebody will say, well, wait a second, it's similar to 176D where you have to operate in good faith, and the courts have said a violation of 176D is a violation of 93A. Therefore, a violation of the the prompt pay statute requiring certification in good faith also should be a violation of Chapter 93A. I think I don't know as though the courts are going to find that way, but I think that there is a logical argument to be made in that regard. And it's not to say, by the way, that if you certified in good faith and you're wrong, that's a 93A violation. Right. You can be wrong. You're allowed to be wrong, just like you were in the past. You just have to do a good faith review and report it in that way. And the last thing I'll say before we segue over to payment bonds is I think it's important, because I've got clients that ask me this a lot, is if somebody complies, if the tier above properly rejects under the prompt pay statute, does that mean I lose the case? And the answer to that is absolutely not. You can still have a breach of contract claim for not getting paid the way you're supposed to be paid. It would just mean that you don't win automatically under the prompt pay statute.
So let's talk a little bit about that. If somebody does properly reject, what's next? Is it filing suit? You lose that leverage of having caught them in violating the Prompt Pay Act. But what does it look like going forward? It's a lawsuit?
Yeah, well, I mean, one of the ways is assess whether there's a payment bond on the project. And I know we'll talk about mechanics liens in a moment, but another avenue could be, was the tier above you, the general contractor usually, well, not always, but sometimes on private jobs, required to furnish a payment bond? If there was a payment bond required, you're going to want to make a claim on the payment bond to try to exert some leverage.
Okay, another bit of leverage of turning the tide when you're trying to push up against maybe a better funded, better positioned opponent. But I want to go back to prompt pay, and when there's a violation of prompt pay, you've seen it because you're looking at the dates, you see whether the rejection appears to comply, whether it points to contractual provisions and factual bases, and then also has the good faith certification of that rejection. But let's assume that they don't have one or all three of those. Do you have to wait to use that leverage in litigation, or when are contractors starting to be able to use it? I imagine once they violated it and they're outside of the clawback period, there is no way to fix that violation, and now you've got them dead to rights. So how do you use it without having to go all the way forward with litigation?
Yeah, I mean, I'd be curious as to Drew's thoughts on this too, but I mean, it's going to be a case-by-case assessment. If the GC messes up responding under the prompt payment statute, but you're talking about $20,000, and you know that you've got payment requisitions coming that are worth a whole lot more than that, you may not want to alert them to the prompt pay statute over the $20,000 issue. Hold it in your pocket and see how they deal with some of the future payment applications, where if they fell down on the $20,000 one, they may very well fall down on the bigger one. And so you're going to need to make a strategical decision as to whether you try to hammer them with that and when you do it. Of course, like always, your relationship with the tier above matters. You know, when you're thinking about using prompt pay to hammer somebody above you, and rightfully so, it's a statutory right. You're not supposed to have to fund the job. You're certainly weighing the relationship issues, because once you get to the point of hammering them with the statute, you're probably at that point where you're fighting.
And Drew, you'd agree, what's good for the goose is good for the gander. When you're consulting clients on prompt pay, it's just as important that they understand that they have to be complying themselves with subs that are downstream from them, right?
Right. So, the one thing about prompt pay that distinguishes it from other causes of action is that it's pretty clear factually whether they responded timely, right? I mean, if they missed the deadlines, they missed the deadlines. It's indisputable. If they didn't certify something in good faith, it's indisputable. The question then becomes, how do you use this failure on their part to extract the most benefit that you can on your end? And sometimes it's filing right away. I mean, if you have an arbitration clause, you have to take it through the arbitration process and bring a claim right away and affect your rights. And sometimes it's the right thing to do because what it does is it rights a ship that's listing dangerously to the left, right? So if you bring this to the attention, then sometimes what it does is it forces the parties, all the hierarchy in the construction circle to then realize that they have obligations to do this. And if from that point they're either going to comply or they're not, and if they don't comply, then chances are they're going to falsely certify rejections on payment applications, and that gives you the route that we just talked about. But you don't have to do it right away. Sometimes you do wait, and I've seen it in both instances. You wait till the project's completed, you bring it in, you say you violated prompt pay on this one. So it really is kind of on an individual basis. But one of the things that's really important in construction sites is keeping an open dialogue, because every single project has its issues. And sometimes an open dialogue can even prevent you from going down this legal road and into this morass of expense and time and resources that are drained away on a legal process that could otherwise have been addressed in the field with a meeting between the principals of the various companies and say, look, we can't fund your project. We're either going to lien this thing, we're going to nail you with prompt pay, we're going to do something, but we need to be paid, right? What are you going to do to pay us?
That's great. Drew, I want to follow up with, you mentioned liens, and we've talked a little bit about it, and there's an interplay with the Prompt Pay Act and liens, and certainly when we're talking leverage. But just to wrap up the discussion on prompt pay, first of all, understand the respective Prompt Pay Acts in your state. Obviously, we practice in Massachusetts. You have to know both so that you're aware of the rights that you may have and the leverage you may have against upstream contractors or the owner in the case of GCs, but also be aware of your obligations to people that are submitting change order requests and payment apps to you. You've got to make sure that you are properly complying with the statute and that you are certifying that the rejection's in good faith, pointing to the contractual provisions that are the basis for the denial, pointing to the facts, and making sure that you're evaluating this with counsel where appropriate. And certainly you can see that there's strategic considerations. There's all sorts of areas of the law that are evolving that people can trip up and not know about, but also that you may be missing opportunities to be able to use that for leverage. Once they've violated prompt pay, the discussion doesn't end there. In fact, hearing from you two, in my own practice, it just begins. You have to now evaluate, you want to tip your hand because Mike pointed out they may later on in the project fail to comply with prompt pay on much bigger ticket items that would be good to keep in your pocket rather than educate them. And at the same time, it starts to impact relationships. But there may be, as Drew pointed out, times that you want to jump in, use an arbitration clause, and move full speed ahead with the prompt pay violations, which, as Drew noted, these are relatively black and white compared to a lot of other construction disputes. You either comply with the act or you don't. That's really helpful for folks to be thinking about. Drew, you had also mentioned mechanics liens, and it's such a big part of what we do. I know when clients come in and it's a new client, or certainly we educate existing clients on the mechanics lien statute, but a big part of it, I think, is that if it's done correctly, it's often a way to get clients paid without having to engage in drawn-out litigation. So it's one of the more efficient ways to get clients paid. But talk to us about mechanics liens generally and about how you use them for leverage when you're fighting for a client.
Yeah, so just basically, a mechanics lien is a process by which somebody who isn't paid gets some sort of security against a leasehold interest in the case of work for a tenant, or the fee interest, the ownership interest in the property. So they basically put a placeholder there saying, I'm out here, I'm owed this amount of money. Don't forget about me. And by the way, you can't sell this property, you can't transfer your lease, you can't do these other things. With my lien out here, I have a public record that I'm owed money, and now I'm going to execute on that lien. So what a lien does is it creates an encumbrance a visual encumbrance on a piece of property or leasehold interest that lets the entire world know that you're out there and that you're owed money. And if they buy that property, that they're buying it subject to you. So that's basically what a lien is, a mechanics lien. It's called different things in different statutes, but colloquially it's typically known as a mechanics lien. And what I always advise my clients is when somebody owes you money, time is not your friend. And that's very true in the context of a mechanics lien, because every state's different with their mechanics liens, and virtually every state has a mechanics lien statute. But they all have time frames for when you have to do things, when you have to put this notification somewhere that someone can see that you're out there and that you're owed money. In Massachusetts, we do our notifications in the Registry of Deeds. So if it's a fee interest, an owner owns 20 acres of land, they're building this development there, they don't pay the general contractor, they don't pay a subcontractor, they don't pay somebody. We put a mechanics lien to let the whole entire world know that looks to the Registry of Deeds that we're out here and that we're owed money. So really, one of the most fundamental things about a mechanics lien is it's a strict construction statute, which means you have to follow the requirements of the statute strictly, or you lose your lien rights. And the reason they do that is because in many instances, if a mechanics lien is properly asserted, the owner is going to pay twice. The owner will have paid the general contractor for the subcontractor's work, but the general contractor didn't pay the subcontractor, and then the subcontractor brings a mechanics lien, so the owner then ultimately has to pay the subcontractor as well. So the owner will have paid twice.
Point. Is it always the case that when a subcontractor's not been paid and properly puts a mechanics lien timely on the property, that the owner, even if they've already paid the general, has to then pay that subcontractor as well, and in effect, pay twice?
Sometimes yes, sometimes no. If like in Massachusetts, if it's a subcontractor lien on for tenant work, if the owner of the property is a tenant in a building, and the general contractor is a contracts directly with a leaseor, I guess, of that piece of property, then the subcontractor, at least in Mass, won't necessarily, it likely doesn't, have an action against the actual owner's fee in the property. So I don't want to overcomplicate this thing, but it kind of depends on what the statute is in terms of what a subcontractor can grab. But typically in the case where the owner is the owner of the fee and that owner enters into a contract with the contractor, then typically, at least in Massachusetts, that subcontractor might have a shot at the fee on the property, the title to the property. And in fact, one of the things that these mechanics lien statutes do is they enable the creditor, in this case we're talking about a subcontractor, to force the sale of the property to get reimbursed for the expenses and costs that it should have been paid by somebody else.
Drew, I think what our good friend from down the hallway may have been angling at a little bit was the no amount due or to become due defense that can come up and serve as a shield for the owner. In that instance, and forgive me, Nate, if that's not what you were angling.
No, let's talk about that. What is the no amount due or to become due, and tying that into prompt pay is helpful to think about as well.
Can I just touch on that real briefly? I'd mentioned before that time's not your friend when somebody owes you money, and that's a classic example, right? So if you have a mechanics lien in most states, you're going to be capped. Like say you're a subcontractor, and the owner has a contract with a general contractor for $1 million. And the owner has paid the general contractor $800,000, but you're a subcontractor that's owed $250,000. In Massachusetts, you're owed, your lien is capped at the amount due to become due between the owner and the general contractor. So even though you haven't been paid to the tune of $250,000, there's only $200,000 that's owed between the owner and the contractor. So your lien is capped at that amount. So when I say time is not your friend, if the more that owner pays that general contractor, the lower the cap is on your particular lien. So that's why you really can't wait to assert a mechanics lien, because every payment there depreciates what your cap could be. It could also run into situations where the owner sells the property, right? So you're owed $250,000, the owner goes and sells the property and you haven't put a lien on the property. Well, now you're out, right? So you got to act very quickly when you're owed money because, like I say, time is not your friend.
Well, you're speaking to some of the practical reasons why you need to act quickly, Drew, but there's also statutory tight timeframes within which liens have to be recorded and perfected, correct?
Yes. Yes, and they're measured from different things, but go ahead, Mike.
If I could, real quick, I mean, that issue on due or to become due is a huge issue. If you wait, a lot of times what happens is subs finds out that it's not getting paid and it's dragging on. And what the sub only has an inkling of is that there's a real big dispute brewing between the owner and the GC. What the sub doesn't know, perhaps, is whether the GC is in material default. If those circumstances present themselves, that the reason the owner and the GC are having a dispute is because the GC is in default, and it's resulting in the sub not getting paid. And so the sub finally throws its hands up in the air, engages counsel, and we put a lien on. But at that time, the general is in material default of its contractual obligations. There is case law out there that says there is no amount due or to become due. It doesn't matter what the contract balance is. General contractor is in material default of its contractual obligations. There is no longer any amount due or to become due the general. And even though the sub has timely and properly recorded, at the time it did, there was no amount due or to become due, sub loses and gets no lien recovery. It doesn't mean the sub doesn't have breach of contract claims against the general. It just means that it won't recover on the lien. So going to Drew's point, if you, subcontractor, are not getting paid in timely fashion, it is there may in fact be a reason for it above you, and you shouldn't sit on your hands because doing so may screw up your lien rights.
Yeah, I'll give a real life example. We're representing an ownership group. We love the contractor. The contractor did a great job. They had a subcontractor that fell down on the job. The contractor was fighting with a subcontractor, fighting back and forth, but what the general contractor did was they performed the subcontractor's work because the subcontractor fell down. We were very happy with the general contractor. The general contractor was very open with us about the problems it was having with its subcontractor. We knew that the subcontractor was just about to put a lien on the property. We paid the contractor in full. They fully performed. They got everything done. We did that on a Friday because we knew that we were going to get a lien on that property on the following Monday. And they did. They filed a lien on Monday. But guess what? When Monday came around, there was nothing due to become due between the owner and the general contractor, and the subcontractor was out of luck. So this is why this time frame, this importance of keeping track of time and understanding that time's not your friend when somebody owes you money is so crucial, because we could go on for hours about different examples that we've all seen where somebody lost valuable ability under a mechanics lien or other statute to get reimbursed for expenses that they were owed because they waited. And the law doesn't favor those that wait, and it's certainly true in the context of a mechanics lien.
Drew, with regards to mechanics lien and the no amount due or to become due defense, do you have to go through all of the steps of the lien, that is the notice of contract, and then record statement of account, and then record a certified copy of the complaint? Or is it just a matter of getting one of those steps in before the argument starts to arise about whether any further amount is due or to become due?
Well, it's from the date that you file your notice of contract, right? That's the first. In Massachusetts, it's called the notice of contract. You file your notice of contract, now you're on record, and that's the point from which the determination is made of what is due to become due at the hierarchy of the tier above you.
Well, is there any reason then, let's use subcontractors, because I know there's a distinction, and I think Mike will speak to it. Any reason why a subcontractor shouldn't put a notice of contract on the project right from the beginning to be able to cut off that argument?
They certainly can.
And that's a notice of conflict.
Yeah, they certainly can, and there's also a thing in Mass called the notice of identification, which changes, your hierarchy in terms of payment caps. But you certainly can, and in fact, you do see that with some degree of frequency. But typically, what happens when that's done is the owner will require the general contractor to bond off the lien. The general contractor will require the subcontractor to bond off the lien, and then you're in that kind of a situation where who bears the cost of those bonds, and how do they get pushed down, et cetera. So you certainly can, and if you do, the amount due to become due is certainly at its peak at the beginning of the project.
Yeah.
But it also creates problems down the road, and it can damage relationships.
Mike, do you disagree?
Yeah,
Is a notice of contract recorded early in the project by a sub
I think
a death for that relationship?
there's a huge difference between notice of contract getting recorded by a general versus a sub. With a general, it should be a good practice, and it is not a notice of conflict under the mechanics lien statute. That is, it is identified in the mechanics lien statute that a general contractor can record a notice of contract, and that as long as it continues to sign partial lien waivers as it's getting paid, that the commercial lender has to continue lending. If a subcontractor puts a notice of contract on, it is a notice of conflict. Lender can stop lending, and it's going to jam up the project. Going back to the general contractor, not only does the statute allow for it, but there's a good reason that it should be standard operating procedure, and that is under the prompt pay statute. Even if you have good, valid, enforceable pay if paid language in your subcontracts, if an owner becomes insolvent and that is the reason for non-payment to the general, pay if paid between the general and the subs is only going to be enforceable if the general contractor has recorded a notice of contract at the outset before work begins. And even then, the general contractor still is going to have to respond to payment applications in the timely way and explain, if they're not paying, why they're not paying under prompt pay, under the pay if paid language in the contract, and the fact that the owner's become insolvent. But my point is, general contractor should be recording notice of contract at the project outset to give itself some protection. Statute doesn't hurt the project. Subcontractors, if they're recording notices of contract at the outset, it jams things up. There is the other document that Drew was talking about is a notice of identification. That is for subcontractors and vendors who do not themselves have a direct contract with the general contractor. So subs and vendors to subs, they're supposed to send a notice of identification to the general contractor within 30 days of starting work to protect their lien rights. It's not something that gets recorded at the registry. It's just something that says, hey, we're out here. But I know you don't have us on to turn the statute inside out. The point to understand with respect to payment leverage is, if you're able to put a lien on, you now have an encumbrance on the property. You have the attention of the people above you who now are going to have to react to it. And they're either going to have to bond it off, which is much harder for an owner, or they're going to have to get serious about having a good faith, fair discussion with you about coming to a resolution in a way that they may not otherwise be inclined to do. Again, bringing things to the forefront, trying to exert good faith, statutory right pressure that flips the leverage where you're not holding the money. Flipping the leverage being the key to trying to get a faster, better resolution for you. You've got a statutory right to put a notice of contract on, and under the prompt pay statute, in order to protect yourself under pay if paid language, you have to at the beginning.
Understood.
Let me finish.
Yeah.
As long as you're signing partial lien waivers along the way,
Yeah.
the lender has to continue lending. So, I mean, the statute is set up, both statutes are set up to assure that everybody gets kept happy and protected. If you're telling a general contractor not to record a notice of contract at the outset of the project, you're damning them under the prompt pay statute.
Mike's made the point earlier, that doesn't mean that you've lost all your claims, however. It just may mean that you can't bring the mechanics lien or it gets discharged. You likely still have a breach of contract claim. The question is whether, is there a general to recover against, or can you bring that in a way against the owner, the entity that you contracted with, that's going to allow you to get recovery. We speak about mechanics liens as leverage because they are recorded against the property itself and the equity potentially in that property. So you really do get folks' attention. And if you have to recover and go through the process all the way through foreclosing on the property, it's a way to get paid. So folks understand this at the ownership level, at the GC level. So when that happens, they're going to take your claim seriously and have a conversation. And I think we all have seen that you don't always have to go all the way to litigation to be able to effectively use the leverage of a lien to get a prompt and relatively efficient and inexpensive result on behalf of clients. Mike, question, can the mechanic lien get limited?
Nate, just real quick, Mike and I just had one of these, right? We filed the mechanics lien, they weren't going to pay us. They brought an action to dissolve our mechanics lien. We beat them. We defeated their action to dissolve our mechanics lien. Next thing you know, they're writing us a check. So even if you have to file a lawsuit, it doesn't mean it's over. It doesn't mean you're going to have to wait years to get paid. In our case, we get paid the minute right after we defeated their attempt to dissolve our lien. But go ahead.
I
Yeah,
think on
good
the
point.
flip side, just talking about leverage, Nate, is if you're the one that the other side is trying to leverage, you should take a careful look to see whether the other side has met their statutory obligations. We're in the process. We just knocked one off for one client, one GC client, who the owner was jumping up and down on because a sub had recorded a lien, but it wasn't in compliance with the statute. We knocked it off. That same problem party is involved on another project, and we're in the process of filing an action to knock that lien off as well for the same reasons. The point is, leverage, and when we're saying leverage, we mean good faith exercise of statutory rights to try to put yourself into a stronger position. Just because somebody attempts to exercise those rights against you doesn't mean they actually have them. And you should talk with us or talk with whoever your counsel is about whether they have met their statutory rights, because the statute does afford a summary process, Section 15A of the Mechanics Lien Statute, a summary process to try to get a quick resolution to knock the lien off.
Yeah, pretty severe consequence if it's a valid lien, but with that comes this, like, especially heightened obligation to comply with it. So strict compliance with a lien, it's critical you meet the deadlines, it's critical you use all the words as required by the statute, but there's also the flip side of that, which is if someone hasn't complied, you can get rid of the lien and then fight about the underlying claim. So that's really helpful. So we've talked about mechanics liens, we've talked about prompt pay, we've talked about bonds. I think this is a topic that you two could both agree on, I hope. Although it's fun to see you go round and round. But okay, can we agree that attorney's fees language is always good to have in a contract and really is a source of great leverage? But because and this will bring me back, one point I wanted to ask you, Mike, about is what a mechanics lien can consist of. And it can't consist of attorney's fees. You cannot lien a property for your attorney's fees. It goes to the improvements to the property itself, and those fees are not part of that. So let's, Mike, talk to us about attorney's fees provisions, and then Drew, I want to hear your thoughts, and I'll be thrilled if you disagree with Mike on the value of attorney's fees language in the contract.
I just might.
It's a matter of just strengthening your hand. That is, what most lay people wouldn't know, and we wouldn't know if we weren't lawyers, I don't think, is that unless you have a contractual right to recover your attorney's fees, you are very likely not going to recover your attorney's fees. That is, if you don't have a contractual right, then the only way you can recover attorney's fees is via a statutory right. And the statutory rights are very limited. There's the consumer protection statute that can be used, but that's a really high bar to hit in order to trigger attorney's fees. On public construction, under the payment bond statute, there is a right to recover attorney's fees. But again, a lot of projects aren't state public construction projects. They're, private projects wherein you don't have the right to recover your attorney's fees unless you have it in the contract. And so if you have it in the contract, it doesn't necessarily mean that you're going to recover them, but it is a way to say to the other side early on, look, we may have an honest disagreement, but I'm going to get something. And when I recovered my something, your client will have spent all this money on you, and then they're going to have to pay our reasonable attorney's fees as well. So it makes sense to come to a resolution now that's reasonable for everybody. If you don't have the attorney's fees provision, the conversation that you could be having with opposing counsel is, hey, Mike, we disagree on things, and we're probably going to disagree on things to the end of time. And even if you're entitled to recover something, your client's going to pay you 5, maybe six mid 6 figures to be fighting about this case for the next 3 to 5 to 6 years. And at the end of the day, we know you're not going to get those attorney's fees back, so you better make a deal with us now. It's the best business solution.
Drew, you have to agree with Mike that you want to have attorney's fees.
I hate to disappoint you. So here's how I look at the attorney's fees. If I'm representing a contractor and the owner has a provision in the contract says if the contractor breaches the contract, they get their attorney's fees. Then of course I want my attorney's fees as well for them if they breach their contract.
You want it to be mutual.
Yeah, I want it to be mutual. But, this goes to this whole prevailing party. If the prevailing party gets their attorney's fees, and I think that clause can sometimes lead to unnecessary litigation. Because although at the beginning of the case they both look at this financial cliff and say the attorney's fees could well exceed the cost that we're actually fighting about, let's work out an agreement here. What often also contrary to that, what happens is a lot of times at the beginning of these disputes, both parties feel that they're right and that they don't want to compromise, and that they both are emboldened to continue on to this litigation because they see that there's a cost to collect clause at the bottom that says if I win, I get my attorney's fees. And it's always the case that at the beginning of the case, most parties feel that they're going to win the case, and having an attorney's fees clause can encourage them to continue on with litigation rather than look at the financial cliff that a loss might cause to them. And it's only through discovery and other practices and fact-finding and legal analysis that occurs later on that the parties begin to realize the strengths and weaknesses of their respective cases. But by that time, they're already down this financial cliff of, the prevailing party gets their cost of attorney's fees. What I often do now when I'm negotiating these contracts is I'll put some sort of a trigger point in there, and that says that before the dispute is filed, the parties both have to identify what they want, and whoever comes closest to what they want at the end of the litigation, then that's the party that gets their cost of attorney's fees. Or I'll throw in a clause that says if you get 80% or if you get 75%. And that avoids a situation where somebody, wants $1 million, the other side wants nothing, and it comes in that they're awarded $10. Well, the party that wanted something, they won because they got the $10. And the party that lost has to pay the $10. But did the party that lost that was facing $1 million really lose when at the end of the day they're paying $10?
Yeah, you got to
So who's the prevailing party, right? So now all of a sudden you're looking at a prevailing party clause, say, well, you got your $10. You were looking for affirmative money. I was looking to wash this thing out. So I try to avoid those sort of situations if I'm going to use an attorney's fees or prevailing party clause, and try to define what a prevailing party really is. And I also like to create a situation that before they file litigation and incur all these costs, to have them exchange, what would be something that they would accept in the case, and make that the goalposts for the award of an attorney's fees if the case should go all out and reach a judgment or a conclusion of some sort.
Like, other thoughts on attorney's fees, nuances to it?
No, I agree. I'm not a fan of prevailing party language, though I think I'd probably take it as opposed to nothing.
Fair enough. All right. Well, we're getting to the end of our time together. This has been fun, and at times more fun than I expected, although I guess knowing the two of you, I didn't think you'd come here and just give each other high fives. So this made for a fun discussion. We talked about prompt pay. We talked about attorney's fees provisions. That one went pretty smoothly. Mechanics liens, and we talked about bonds. All various ways that, in conjunction with speaking with your attorneys and with your team, you can try to use those appropriately and ethically as leverage to get a prompt, efficient result rather than go through the entire battle of litigation. But if you're in litigation, these are things that are still going to be pertinent to the steps as you get to a trial, and ultimately questions for a judge or a jury. So appreciate you both being here today. Before we wrap things up, Drew, let me ask you a question as part of the trial think tank. A little bit at the end here, we do just getting your high-level thoughts, but what's some advice you could leave our listeners with regards to maximizing leverage on construction projects?
Yeah, so I've said it now several times, but time's not your friend when somebody owes you money, right? Just figure out what you need to do, because you're going to lose your leverage, you're going to lose your legal rights, and you're going to lose your ability to get reimbursed for your hard-earned work if you wait. Time's not your friend. If there's any takeaway I could give people listening today, that would be it. Time is not your friend when somebody owes you money.
That's great advice. Mike, thoughts to close us out with?
No, I was going to say the same thing. I completely agree. The longer you sit on it, the greater chance there is you're not going to get your money back, even if or you're not going to get back a huge percentage of it. I mean, setting aside all the stuff we talked about today, consumer studies have shown, or collection studies have shown, that when you get out 90 days plus in dollars owed to you, there is a significant reduction in what you get back. And so just understanding that, you should know, I shouldn't sit on this. Kicking the can down the road is not going to help you.
Sure. Beyond the strict statutory requirements of putting a lien on the property, for example, you've got requirements there that cannot be deviated from. The reality is, if you're waiting and waiting to get paid, you probably don't have a relationship that's worth salvaging at that point, and you have to take the appropriate timely actions to make sure you're protecting your company and you're putting yourself in the best position to be paid and maximizing the leverage. So thanks, Mike Sams. Thanks, Drew Colby. Appreciate you joining us today. And we look forward to further conversations with regards to all sorts of construction topics, employment topics, and business litigation topics with TrialThink. Thanks for listening.
Thank you.
Thanks for listening to TrialThink. Don't forget to like, subscribe, and join us for all of our upcoming episodes.